Hello friends and welcome. Today we are discussing constructive joint liability, common intention and common object, Section 34 and Section 149 of the Indian Penal Code. To begin with, let me give you a brief introduction about what liability means. When a person has committed a wrong, he is said to be liable. Thus, liability is the condition of the person who has committed a wrong. The general rule is that a person should be punished only for the offence he or she has committed and not for the offence committed by others. However, when two or more persons commit a crime jointly, each one of them is equally liable as if he alone has committed such an offence. Their liability is called joint liability or constructive joint liability. The liability is joint and constructive in the sense all of them are equally liable and are awarded the same punishment. For example, A, B and C jointly went to D's house to kill him. In fact, B alone fired at D and killed him. However, A, B and C are equally liable and the same punishment is awarded to all of them. This lecture in particular deals with number 1, common intention, Section 34, and number 2, common object, Section 149. First of all, we shall talk about Section 34. Acts done by several persons in furtherance of common intention. When a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. A very important thing to understand is the principle of joint liability. There are some provisions in the Penal Code which determine the liability of a person committing a crime in combination with some others. In all such provisions, a joint liability is created either because the intention is common or the object is common to all the persons forming a group alleged to have committed a crime. Now the ingredients of Section 34, some of which are: number 1, there must be 2 or more persons. Number 2, they must have common intention to commit the offence. Number 3, the criminal act must have been done in furtherance of the common intention. And number 4, participation in the action by all the accused. Let's discuss each one of these in detail. First, 2 or more persons. To constitute Section 34, there must be at least 2 offenders. It's necessary that each one of them has consented to join the crime. Active participation of each and every offender is not necessary. Number 2, common intention. Common intention implies pre-arranged plan, prior meeting of minds, prior consultation in between all the persons constituting the group. Third, in furtherance of common intention. The expression "in furtherance of" means action of helping forward. The offence is committed in accordance with the common intention or putting the common intention in operation. And number 4, participation in action. The persons involved in the offence must have consented to it. Their physical presence coupled with actual participation is necessary. He need not involve in commission of the offence. If he joins the other offenders and simply stands at the door, he is liable under Section 34 of the Indian Penal Code. In order to understand it clearly, we quote a case, Barinder Kumar Ghosh versus Emperor, popularly known as Postmaster murder case. Barinder Kumar, along with 2 of his companions, went to a post office for committing robbery. One of his companions opened fire, causing death of the postmaster. The 2 others ran away without robbing the money, but Barinder Kumar was caught with a pistol. He was tried under Section 34/302. Barinder Kumar denied the charge on the ground that he did open the fire, but he had no intention to kill the postmaster. His plea was denied and was held guilty of murder. The other case on the point is of Mahboob Shah versus Emperor, popularly known as Indus River case. In this case, Al-Adad, the deceased, along with his friend Hamidullah, went in a boat for collecting reeds on the banks of the river Indus. Mahboob Shah warned Al-Adad and his companion not to cut the reeds, as the land belonged to him. Al-Adad did not care a pin to his words and collected 16 bundles of reed and loaded it in the boat. Mahboob Shah's nephew Qasim Shah asked them to return the reeds collected from their land. As Al-Adad refused, Qasim Shah obstructed the boat and pushed Al-Adad. Then Al-Adad with a bamboo pole struck Qasim Shah. Qasim Shah shouted for help. On hearing the shouting, Wali Shah and his son Mahboob Shah reached there with loaded guns in their hands. Wali Shah fired at Al-Adad and Mahboob Shah fired at Hamidullah, who was injured. Wali Shah absconded, but Mahboob Shah and Qasim Shah were prosecuted for the murder of Al-Adad. The Sessions Court convicted Mahboob Shah with death sentence under Section 302, read with Section 34 IPC. Qasim Shah was sentenced to 5 years rigorous imprisonment under Section 307, read with Section 34 IPC. On appeal, Lahore High Court acquitted Qasim Shah on the ground that he had no common intention to kill. However, the court confirmed the conviction of Mahboob Shah under Section 302/34 IPC on the ground that common intention came into being when Mahboob Shah opened fire along with the other accused Wali Shah, who was absconding. Simultaneously, in the same direction, Mahboob Shah preferred an appeal before the Privy Council. The Privy Council set aside the sentence or conviction and observed, number 1, to invoke Section 34 IPC. It must be shown that the criminal act is done in furtherance of the common intention of all. It should be proved that the act was done pursuant to the pre-arranged plan. Number 2, there was no evidence, direct or circumstantial, that the accused, Mahboob Shah, must have been acting in concert with the other accused, Wali Shah, absconding in pursuance of a concerted plan. Number 3, there was no evidence that the appellant and Wali Shah entered into a premeditated plan to bring about the murder of Al-Adad. Number 4, the essence of joint liability is to be found in the existence of a common intention. And number 5, the inference of common intention under Section 34 should never be reached unless it's a necessary inference deducible from the circumstances of the case. Same or similar intention must not be confused with common intention. In a recent case, Virendra Singh versus State of MP, court in this case held that the vicarious liability under Section 34 can arise only when two conditions are fulfilled, that is, the mental element or the intent to commit the criminal act conjointly with another or others, and the other is the actual participation in one form or the other in the commission of the crime. Thus, the dominant feature of Section 34 is the element of intention and participation in the act. This participation need not, in all cases, be by physical presence. Common intention implies acting in concert. Now let's move on to common object, Section 149. Section 149, like Section 34, is the other instance of joint liability. Section 149 creates a specific offence. It reads as, when 5 or more persons commit a crime in prosecution of common object, each member of such group will be liable for the act in the same manner as if it were done by him alone. Section 149 of IPC deals with a joint liability of the members of an unlawful assembly. For application of Section 149, there must be an unlawful assembly as defined under Section 141 of IPC, which says, an assembly of 5 or more persons is designated as unlawful assembly if common object of the persons composing that assembly is, number 1, to resist the execution of law or legal process, number 2, to commit any mischief, criminal, trespass or other offence, number 3, to overawe the government by using criminal force or show off criminal force. Number 4, to compel any person by means of criminal force to do what he is not legally bound to do, or to omit to do what he is legally entitled to do. Number 5. Forcible possession or dispossession of property. This section is based on common rule of law to protect public peace from dangers to it caused by the combination of forces of a number of persons. The essential ingredients of Section 149 are: there must be an unlawful assembly as defined in Section 141. Criminal act must be done by members of such assembly. Act done is for prosecution of the common object of the assembly. Members have voluntarily joined the unlawful assembly and knew the common object of the assembly. General defences which can be pleaded by the accused are contained in Sections 76 to 106 of IPC. When a person is alleged to have committed an offence, he is tried in the criminal court. The court, before declaring him guilty of the offence, gives him an opportunity to get exemption from criminal liability. Such provisions available to the accused to get exemption from criminal liability are called general defences or general exceptions. Sections 76 to 106 of IPC deal with general exceptions. One such defence is mistake. Sections 76 and 79. The term mistake literally means commission or omission of an act ignorantly or unintentionally causing injury or damage to another or others. Section 76 and 79 applicable to mistake of fact and not of law are based on common law, maxim ignorantia facti doth excusat. Ignorantia juris non excusat. Ignorance of fact is an excuse, but ignorance of law is no excuse. Now A. Mistake of fact is a good defense in criminal case. Section 76 declares that nothing is an offence which is done by a person who is bound by law to do it, or by reason of fact and not by mistake of law, believes himself to be bound by law to do it. For example, A. An officer of a court of justice being ordered by that court to arrest Y, and after due enquiry believing Z to be Y, arrests Z. A has committed no offence. Or A. A soldier fires on a mob by the orders of his superior officer, in conformity with the commands of law. A has committed no offence. In R versus Mrs. Tolson, Mrs. Tolson married Mr. Tolson in September 1880. Her husband deserted her in 1881. Mr. Tolson's whereabouts were unknown for more than 7 years. She made all enquiries about her husband and learned from reliable sources that he died in a shipwreck. Mrs. Tolson got married in 1887, reasonably believing that her husband died. Sometime after her remarriage, her husband reappeared and charged her for bigamy. The court in this case acquitted Mrs. Tolson of bigamy, as what she did was on reasonable belief that her husband was dead. So her act of remarriage was a mistake of fact and not of law. Mistake of fact will afford no protection if the act of the accused is mala inse, that is bad in itself, in R versus Prince, 1875. Mr. Prince, the accused in the instant case, was in love with a girl, Miss Annie Phillips, who was below the age of 16 years. The accused had taken away the unmarried girl from the lawful custody of her parents with an intention to marry her. He thought that she was above 16 years and the girl told him that she was 18 years old. The father of the girl lodged a complaint alleging that Prince had illegally taken away his unmarried minor daughter below the age of 16 years. Prince was arrested and criminal proceedings were instituted against him. The court, through Blackburn J., held that Prince had committed an act which was mala inse, and as such mistake of fact about the age of the girl could give no protection to him. If this defense is to be successful, the law requires that following conditions shall be fulfilled. A. The mistake must be of such a character that had the supposed circumstances been real, they would have prevented the alleged liability from attaching to the person in doing what he did. It is no defense for a burglar who breaks into house number 5 to show that he mistook that house for number 6. B. Mistake must be reasonable one. C. The mistake, however reasonable, must relate to matters of facts, not to mistake of law. Now, mistake of law. The term law used in this connection means general law of the land, but the rule applies to all bylaws, rules and regulations having the force of law. Ignorance of law is no excuse either in case of a native or a foreigner. Everybody is presumed to know the law of the land. Hence, mistake of law is no defense. Section 79 reads as, nothing is an offence which is done by any person who is justified by law or who by reason of a mistake of fact and not by reason of mistake of law in good faith believes himself to be justified by law in doing it. For example, A sees Z commit what appears to A to be a murder. A, in the exercise to the best of his judgment exerted in good faith of the power which the law gives to all persons of apprehending murderers in the act, seizes in order to bring Z before the proper authorities. A has committed no offence, though it may turn out Z was acting in self-defense. Here we quote a case, R versus Bailey. In this case, the accused was away from the coast of Africa when a statute was passed by British Parliament, and he even could have known by any means about the passing of the statute under which he was charged. The court held him guilty, disallowing his plea of want of knowledge of the law. In R versus Wheat and Stock, the accused in this case was an illiterate. He was informed in good faith that he had been granted divorce and he got remarried. His first wife charged him of bigamy. The court held him guilty of bigamy and convicted him. Tolson's case and Wheat's case are quite different from each other. In the former, there was a mistake of fact, which is excusable, and hence Mrs. Tolson was acquitted, while in the latter case there was mistake of law, which is not excusable, hence the accused was convicted. Now, judicial and executive acts. Section 77 and Section 78 of IPC grant immunity to judges acting judicially and to other persons who do acts in pursuance of the judgment or order of the court. That is, Sections 77 and 78 of IPC provide for exemption from criminal liability in respect of judicial acts, that is, the acts of judges and courts. This protection is afforded to them from civil suits under Judicial Officers Protection Act 1850. Section 77 declares that nothing is an offence which is done by a judge when acting judicially in the exercise of any power which is or which in good faith he believes to be given to him by law. So, if a judge grants death sentence to an accused, he can be held guilty of murder. If the judge acts without jurisdiction, he will not be protected. A judge can be punished for corruption and malice under Section 219 and Section 220. If a judge or judicial officer confines a person wrongfully, it must be proved that he corruptly or maliciously confined that person wrongfully. Similarly, if a judge does a wrongful act having no connection with his judicial functions, he will be held guilty like any ordinary person. In Meghraj versus Zakir case, the Allahabad High Court held that no person acting judicially is liable for an act done or ordered to be done in the discharge of his official duty within the limits of his jurisdiction, and in such a case, the question of acting in good faith does not arise. The question of good faith is irrelevant only when judge acts without jurisdiction. The immunity extends even to acts which constitute even an abuse of it. Section 78 affords protection to officers acting under the authority of a judgment or order of a court of justice. Section 78 reads as follows: Nothing which is done in pursuance of or which is warranted by the judgment or order of a court of justice, if done whilst such order or judgment remains in force, is an offence, notwithstanding the court may have had no jurisdiction to pass such judgment or order, provided the person doing the act in good faith believes that the court had such jurisdiction. This section protects the ministerial officers for the acts done pursuant to the judgment or order of a court. The good faith and belief in the legality of an order issued by a competent court are the two conditions which should be satisfied to protection under Section 78. If an executive officer lacks bona fide belief, he will not be entitled to the exception. As per verbal orders of the judge, the complainant was kept in custody, for which the bailiff and process server, in believing that oral orders justified their action, was purely a mistake of law and not of fact, and therefore rightly convicted. This immunity has been granted for effective administration of justice. That's all. Thank you.